Namaste everyone, I am Taniya Pandey and I welcome you to courts this week on LiveLaw. Every week I am here with the most recent court updates from across the country. Subscribe to LiveLaw to continue receiving legal updates and click the bell icon to not miss any videos from us. We'll begin the episode with judgments from the Supreme Court and then cover High Courts and other courts. The Supreme Court has stayed a Bombay High Court order directing Bajaj Allianz General Insurance to compensate under the Pradhan Mantri Fasal Bima Yojana over 3.5 lakh agriculturists in the Osmanabad district of Maharashtra for post-harvesting losses caused to soybean crop in the Kharif season 2020 on account of heavy rainfall. The Apex Court added that the stay of operation of the impugned judgment will be subject to the insurance company depositing an amount of Rs 200 crores with the registry of the court within a period of 6 weeks. The bench of Justices J.K. Maheshwari and Hima Kohli was hearing the SLP against the May decision of the Bombay High Court on a string of PILs, praying for direction to the insurance company or the government authorities. The Supreme Court on 24th June dismissed a petition filed by Zakia Ehsan Jafri challenging the closure report filed by SIT, discarding the allegations of larger conspiracy by higher state functionaries, including the then Gujarat Chief Minister Narendra Modi and 63 others in the Gujarat riots of 2002 that ensued the Godhra train massacre. A bench of Justices A.M. Khanwilkar, Dinesh Maheshwari and C.T. Ravikumar upheld the decision of the magistrate in accepting the closure report filed by the Special Investigation Team in the larger conspiracy case. Jafri, the widow of Congress MP Ehsan Jafri, who got killed in the Gulbarg Society massacre during the 2002 Gujarat riots, filed a special leave petition in the Supreme Court challenging the October 2017 judgment of the Gujarat High Court. The Supreme Court has held that the principle of estoppel or acquiescence will not apply in a selection process when it is held contrary to the relevant rules. A bench of Justices Dinesh Maheshwari and Vikram Nath was considering an appeal relating to the filling up of 14 posts in Class 3 Junior Clerk in the Banaras Hindu University by way of promotion. The notification inviting applications from Class 4 employees for promotion to Class 3 had not prescribed that an interview will be conducted in addition to the typing test. The service rules also did not mention the same. However, the Board of Examiners conducted an interview as well and finalized 14 candidates. The selection process was challenged before the Allahabad High Court in light of the unprescribed interviews. A single bench of the High Court set aside the selection process by holding that a grave error was committed by preparing the merit list on the basis of the interview as well. However, a division bench of the High Court on appeal by the BHU set aside the judgment of the single bench on the ground that the petitioners, after having participated in the interview without protest, are estopped from challenging the selection process after becoming unsuccessful. Stressing that the preventive detention law strikes hard on the freedom and liberty of an individual and cannot be exercised in a routine manner, the Supreme Court has observed that the powers to be exercised under this law are exceptional powers which have been given to the government for its exercise in an exceptional situation. The bench of Justices C.T. Ravikumar and Sudhanshu Dhulia was hearing an appeal against the March decision of the Telangana High Court, by which the habeas corpus writ petition of the petitioner wife challenging the order of prevention of detention of her husband had been dismissed. Cancellation of bail cannot be limited to the occurrence of supervening circumstances, the Supreme Court has observed. The bench of CJI N.V. Ramana and Justices Krishna Murari and Hima Kohli made this observation while it allowed an appeal against the judgment of the Allahabad High Court, which granted bail to a murder accused. While setting aside the bail, the bench observed that the High Court has not taken into consideration the criminal history of the accused, nature of crime, material evidences available, involvement of the accused in the said crime, and recovery of weapon from his possession. In the judgment, the court discusses the principles governing grant of bail and also the importance of assigning reasoning for grant or denial of bail. Let us now go over judgments from the High Courts and other courts. The Delhi High Court recently granted an injunction in favor of the Sony Entertainment Network against rogue websites illegally telecasting International Cricket Series 2022. The bench of Justice Sanjeev Narula was hearing a suit filed by Sony Media Entertainment Network Limited, an order of permanent injunction against the defendants to restrain them from infringing the rights of the plaintiff in the forthcoming India-England International Cricket Series 2022. The Jammu and Kashmir and Ladakh High Court has held that control over the district judiciary vested in the High Court in Article 235 of the Constitution of India is complete and absolute and provided only to ensure the independence of the judiciary and to achieve effective separation of powers. A division bench of Chief Justice Pankaj Mittal and Justice Sanjeev Kumar held that the word control used in this provision, accompanied by the word vest, is a strong word and shows that the High Court is made the sole custodian of the control over the judiciary. The Karnataka High Court has rejected a petition filed by Sudarshan Ramesh, brother of Bitcoin scam accused Sri Krishna, questioning the action of central authorities in restraining him from leaving India and travelling to the Netherlands. A single judge bench of Justice S.G. Pandit said that the apprehension of the respondents that the petitioner, being the brother of Sri Krishna, might have been involved in acquiring the proceeds of crime at this stage is to be respected, since the investigation is still under progress. The bench, on going through the records, noted that no right is absolute and that rights may be restricted by following the procedure prescribed under law, and upheld the lookout circular issued by the Enforcement Directorate. While allowing a revision of the order of the judicial magistrate rejecting the application for further investigation, the Madras High Court recently observed that an application for further investigation can be made even after the commencement of trial. The court observed that bringing out the truth was of utmost importance and that Section 173, subsection 8 of CRPC does not put any fetter on the police to conduct a further investigation after the commencement of trial. The Kerala High Court has held that Section 438 of the Code of Criminal Procedure has no restrictive mandate that a person outside India cannot file an application seeking anticipatory bail. The only limitation is that prior to the final hearing, the applicant must be inside the country to enable the court to impose and enforce conditions contemplated under the statutory provisions. The pronouncement was made by a single bench of Justice B.K. Thomas while granting anticipatory bail to actor producer Vijay Babu in a rape case. A Delhi court on 2nd July denied bail to co-founder of Alt News, Mohammad Zubair. He was arrested recently by the Delhi police for allegedly hurting religious sentiments and promoting enmity through his tweet made in the year 2018. Chief Metropolitan Magistrate Snigdha Sarvaria of Patiala House Court pronounced the order and remanded him to 14-day judicial custody. With this, we've come to the end of today's episode. I'm Taniya Pandey for LiveLaw and you're watching Courts This Week. Have a wonderful day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.